Hi guys, my name is Musawenkosi Nyangani. So I'll be presenting on an opening statement. An opening statement is a brief introduction in fact-finding procedures which the court starts with during an adversarial trial. It is used in both the civil and criminal trial. It usually occurs when a party is given an opportunity to explain their case and the evidence which supports their argument. Opening remarks are often made by the party which bears the burden of proof. An opening statement is not compulsory but optional in civil trials that occur at the High Court and in criminal trials. However, in a magistrate court, the magistrate may coerce a party to state their case in a civil trial. In the case of Wenstra v. Oxford Brickwork, it stated that it is self-evident that a party is entitled to explain their case if they intend to present it. However, in order to avoid committing themselves to a single theory of acquittal, the defense may decide not to make an opening statement. This gives them the freedom to pursue an affirmative defense or to rely on the inadequacy of the other party's evidence to satisfy their burden of proof. The opening statement should not contain a comment, and it should be short and brief as emphasized by the respective rules of the court. The prosecutor in trials should not use the opening statement as an incriminating statement made by the accused intended to be proven as the trial progresses. Therefore, it is because the state of such a statement is often accepted and required as a trial within a trial. The purpose of an opening statement is to introduce the case to a jury. An opening statement introduces the parties, describes the nature of the contested issues, gives the jury a brief summary of the relevant facts and evidence, frames the evidence in a way that supports the attorney's theory of the case, and outlines what the attorney expects to. Therefore, the accused or defendant does not have the right to give an opening statement at the beginning of the trial before the prosecution or the plaintiff has begun presenting their case in the criminal trials or high court civil proceedings. The defendants have the choice to postpone their opening statement until the conclusion of the plaintiff's or the prosecution's case. However, if you choose to do so in order to prevent the opposing point from going unrebutted for too long. Let's look at the short clip explaining about an opening statement.
She's about 35 years old. She's a wife, a school teacher, and a devoted mother. Her days in the summertime are spent taking care of her two young daughters. She wakes them up in the morning, makes them breakfast, gets them dressed, and sends them outside to play. She cleans up the house, brings them in for lunch, sends them back outside to play. She does their laundry. She takes care of them. She brings them in for dinner, gets them ready for bed. She makes sure that they brush their teeth, taken a bath, said their prayers. She puts them to bed at night. And then after all of that, she takes a little bit of time for herself. She unwinds, she bathes, she relaxes for a bit and goes to bed, secure in the knowledge that she's safe in her home, that her husband will be home, and that she's going to get to do it all over again tomorrow. Members of the jury, do you know what it sounds like when the world ends? Brandy Alexander does. She would tell you that it sounds like gunshots waking you from a sound sleep. It's the blaring of police sirens, house alarms, and it's the sound of her breath bubbling out of her husband's chest as she tries to bring him back. It's the sound of shouted questions and of children crying. Where's Daddy? What happened to Daddy? I want my daddy. Chris Alexander's never coming back. He was ripped away from his family in an act of brutal violence, senseless violence. And now the state is trying to rip Brandy away from what is left of her shattered family as well. And it's being done following an investigation that lasted a grand total of 3 hours and that looked into a grand total of 1 suspect. Now, as you heard from the prosecution, they have to prove to you, in order to convict Brandy of anything, that she killed Chris and that she did so beyond all reasonable doubt. This means that there cannot be any alternative reasonable explanation for anything that happened. There's only one conclusion, and that you have to find that she killed Chris. The evidence in this case is going to show that that's just not possible. Throughout this case, you'll be presented with a little bit of evidence. And I ask that you bear in mind, what does that evidence show? And what doesn't that evidence show? And at the end of this case, I'll come back and I'll talk to you about why those 2 little girls that you see in that front row should have their mother sent home to them. And why the police and the prosecution in this case should be out looking for the real killer. The killer that they didn't bother to investigate the first time around. Sadly, I can't tell you who that is. We don't know. Because the police didn't bother to investigate the neighbor across the street who admits to having the right caliber gun that caused Chris's death in his hand the night of the murder. They didn't investigate the jilted lover who had authored the threatening notes that were found on his body by the police. They didn't investigate anything. Ladies and gentlemen, I'll come back to you when we're all done, as I've said, and we'll talk all this through, and we'll come to the only reasonable conclusion possible. That's that Brandy didn't kill Chris. She's not guilty. Thank you.
As you have seen from the above clip, an opening statement should not take more than an hour and should be short and precise. State the facts and evidence which are intended to be proven by the prosecution and the plaintiff. That's all on the opening statement. Thank you for watching my video. Please like and subscribe.